It cannot be through executive dominance. Plus, where is the question of a law doing the same thing? Plus, I hope I'm making myself clear. The power came directly from the Constitution. Plus, the law, in fact, breaches the main rule itself, the substantive rule, which is two members of the executive, the prime minister, and a member of his union cabinet. The majority control stays with the executive. So you can't use the procedure, which is the law, to breach the substantive condition of the Constitution. But if you do it, that will violate the basic structure of free and fair election that's recognized in multiple judgments. So let's leave alone a law. It can't even be done through a constitutional amendment. Since Constitution mandates this, Parliament does something, your Lordship say, no, sorry, this is not good enough, go back. It's happened to, that's what is happening between the substance of the law which your Lordships are declaring and the procedure the Parliament is adopting and not following it. There's a lack of independence in that institution. The entire democratic republic is at stake. And I'm not at all overpitching a point. I sincerely believe as to the mechanism of appointment of CEC and ECs, a substantive rule of constitutional law is the first thing Anoop Baranwal did. Second, it said that the procedure for following that constitutional substantive rule is through a law of Parliament. And third, it said that till the time Parliament comes up with a law to follow that rule, here is the interim arrangement, which is the CJI, the Prime Minister, and the LOP. Well, if we look at Anoop Baranwal in this fashion, and my learned friend Mr. Bhushan read out those paras 306, 309, 311, 297. They are very clear that non-executive dominant selection committee is the core substantive constitutional rule. Now, once that rule is there, what does it do, Malots? It sets a bar. Anoop Baranwal sets a constitutional bar. It says, below that line, whatever you do, the legislature you can do. You can come up with A, B, C, D, E, F. But you can't cross that constitutional bar. What they have done by the procedure of law is exactly that. Because the law, in fact, breaches the main rule itself, the substantive rule, which is two members of the executive, the prime minister, and a member of his union cabinet. The majority control stays with the executive. So you can't use the procedure, which is the law, to breach the substantive condition of the Constitution. My lords will have Article 324 for a moment, just the article itself, 324(2). And that will also make it clear, because that's a question which your lordships have repeatedly posed to us from yesterday. Election Commission shall consist of the Chief Election Commissioner and such other number of the election commissioners, if any, as the President may from time to time fix, and the appointment of the CEC and other ECs shall, subject to the provisions of any law made in that behalf by Parliament, be made by the President. So, the power by the Constitution itself was with the President, subject, of course, to a law. But 324(2), without a law, gave the power to the President. If that power itself has been read down in Anoop Baranwal to mean that it cannot be through executive dominance, plus where is the question of a law doing the same thing? Plus, I hope I'm making myself clear. The power came directly from the Constitution. Under 324 clause 2, the power came directly to the President from the Constitution. It was a pure executive power. So when absent a law, this court has said in a constitution bench that even a constitutional source is not sufficient to give pure independent power, because when we read Constitution as a whole, the demand of the Constitution is that the CEC must be appointed through an independent process. If that constitutional source, and that's why I said, no, that's the substantive constitutional rule, which Anoop Baranwal fits and fixes. Well, it's like this. I'll give another example. Well, the classic our basic structure doctrine. Well, procedure of basic structure, there were procedural limitations in Article 368. Two-third majority, present and voting, state approval. Those were all procedural requirements. There was nothing of substance in the Constitution. The basic structure doctrine is a value-based doctrine developed by this court from the Constitution saying no, procedural requirements are not sufficient even for a constitutional amendment. There are value-based substantive limitations on the power. So what Anoop Baranwal does is it puts substantive limitations on the mechanism of appointment. And you can't breach it even through a constitutional amendment. I pitch it higher than Mr. Shankar Narayan did yesterday. Mr. Shankar Narayan said you could possibly have done it through a constitutional amendment process. But if you do it, that will violate the basic structure of free and fair elections. It's recognized in multiple judgments. So leave alone a law, it can't even be done through a constitutional amendment. Because by laws, we'll see the power came from the Constitution itself. The first time, as well as many learned counsels before me have pointed out, that the to and fro between this court and the legislature and the parliament has happened on the question of whether something, the substantive requirement of law is being met or not. Your lordships have in other contexts also sent it, saying substance, Constitution mandates this. Parliament does something, your lordship say, no, sorry, this is not good enough, go back. It's happened to, that's what is happening between the substance of the law which your lordships are declaring and the procedure the parliament is adopting and not following it. That's exactly the situation here as well. So it's nothing new. And your lordships have corrected multiple times. Now, my first submission, there are many instances where your lordships point out a procedural defect and a substantive defect. What the parliament does is, it will just bring in a law, but if the substantive defect remains uncured, sorry, go back again. It's not the first time we are asking your lordships to do it. In different contexts, my lords have done it multiple times. Now, this judgment my lords will have in my Election Commission with all its powers is much, much, much more consequential than a private dispute between any two parties can ever be. For not just for the future of the republic, if I can say that, and future of democracy. Now, my lords, if that is the principle even in private law, it will apply with even more force, my lords, in public law and certainly in the context of Election Commission. My lords, just allow me to labor this a little bit. Election Commission has multiple functions. My lords. I was thinking about it. There are very few institutions, my lords, maybe with the exception of the Supreme Court, which has such wide-ranging functions. It allocates symbols. It announces elections. It, my lords, actually suggests disqualification to the president and to the governor of individual members, which is quasi-judicial. It also, my lords, after announcement of election, literally runs the government. So, my lords, if the Election Commission goes haywire, then in that sense, or if there's a lack of independence in that institution, the entire democratic republic is at stake. And my lords, I'm not at all overpitching a point. My lords, I sincerely believe that it's essential that, my lords, we have an independent commission. And that's why, my lords, in Baranwal have repeatedly said that the protections at the stage of during the tenure and from removal are only part of it. And that's what Dr. Ambedkar also said. But if the appointment process itself is not proper and you have a person who is not independent, then the second and third layer of protection is no use. And it's appointment which the government wants to hit. So that brings us on the third point, implicit in our constitution, which is that Election Commission is a guarantor institution. We don't say it, they say it because it's a later constitution. They have the benefit of experience. But the same principles apply. And just one emphasis I'll say, free and fair are words we use commonly together. They have slightly different meanings. Election can be free, but without being fair. That is also possible. And sometimes it can be fair, but it may not be free. Both are slightly independent things. If the rules of the game are placed in such a manner that they are tilted, if the umpire, if it was a bias, game seemingly will be fair, but no balls will not be given no balls, wides will be made regulars. I'm just using a cricketing analogy. So the rules. That's
don't know much about it.
Your lordships will be, even in India, your lordships have to be aware of it somehow.
You're questioning the decisions of all umpires prior to introduction of neutral umpires.
There would be good decisions as well in that. There would be good decisions. But on balance, the chance of a bad decision was way higher.
Basics you certainly improve.
Yes. So,